What do Alina Habba, John Sarconi, and Lindsay Halligan have in common? None of them were federal prosecutors. None of them practiced in federal court. All of them are political hacks, and all of them are or will soon be bounced, dribbled away from their role that they're supremely unqualified, obscenely unqualified to hold as U.S. attorneys in the United States under Donald Trump. The U.S. attorney for Northern District of New York, once proud, John Sarconi, you're about to get canned by Judge Schofield in Manhattan in favor of Letitia James. Judge Alina Habba, U.S. Attorney Alina Habba, you got bounced 3-0 by the Third Circuit Court of Appeals. Lindsay Halligan, you got bounced by Judge Curry in Virginia. What does it all mean? Why is it happening? What will Donald Trump's next steps be? I cover it all for you at The Intersection, my new podcast. And here's a clip. Let's dive into the James Comey, Letitia James matter. There's some new newsworthy and breaking news stories around their indictments. You'll remember in the last several days, Judge Curry dismissed without prejudice, meaning the indictments could be brought back under certain circumstances, dismissed the indictments against James Comey and Letitia James, the New York Attorney General, because she found, as other courts have found, that Lindsay Halligan is illegally appointed under Section 546 as the interim U.S. attorney in the Eastern District of Virginia. She'd never been a prosecutor before. She'd only been a prosecutor several hours when she went after James Comey, et cetera, et cetera. More importantly, she could not have been appointed as a U.S. attorney because Donald Trump had one opportunity to appoint somebody in that role. He spent it on another person, and then it goes to the district court judges to pick that replacement. That's the argument. But the underlying indictments could be brought back under certain circumstances. So the new reporting is that there's grand juries that are working in Norfolk, Virginia, and Alexandria, Virginia, to bring new indictments against James Comey and Letitia James. So don't be surprised when I come back with updated reporting about it. Now, on Letitia James, I'm hoping that a grand jury will see through this charade, will see the weaponization of the Department of Justice and the vindictive prosecution and not indict. I mean, there's enough publicity out there right now, including on Legal AF. Don't indict if you don't believe the evidence supports it. That's one. But I think she'll probably get re-indicted. That doesn't change the fact that the prosecution is vindictive, and her judge, Judge Walker, is going to have to decide whether the whole criminal case needs to be dismissed, regardless of who the prosecutor is. James Comey's there's a trickier side to that story. Because if they're going to re-indict him under the perjury count, the lying to Congress under 1001 of the code, the statute of limitations has run. Judge Curry ruled that the indictment that Halligan obtained was never an indictment because everything she did was illegal and void. If that's illegal and void, it did not stop the clock on the 2-year statute of limitations, which ran on September 5th. Now, purportedly, there's some argument that they're going to bring another charge against him, not related to his testimony on February 5th, 2020 to Congress. All right, listen, I'll have to see what the charge is going to be. Certainly, it's not going to be Lindsay Halligan getting the indictment. It's going to be a new grand jury. It'll likely be the new number 2. She has a new first assistant, a guy coming out of semi-retirement from Kentucky to work with her that'll probably try to get this indictment. And I think the reason they're trying to get the indictments is because the Department of Justice's world was rocked when 4 days after Lindsay Halligan was fired by Judge Curry, the Third Circuit Court of Appeals, in a unanimous decision 3-0, fired Alina Habba for similar but not identical reasons to be the U.S. Attorney for New Jersey. There's another case involving John Sarconi up in the Northern District of New York that's being heard, just to be confusing, by a judge in the Southern District of New York in Manhattan about whether an investigation started by John Sarconi against Letitia James's New York Attorney General office for violating Donald Trump's civil rights. There's a hearing that's coming up actually on Thursday this week in front of the judge there about Judge Friedrich about whether the John Sarconi was illegally appointed as well, much like Alina Habba. Stay tuned on that one. But it's been a bad run for Donald Trump on these U.S. attorney appointments because he's not picking anybody that can get through the confirmation process with the Senate. He's picking all these partisan political hacks who he knows will never get confirmed or it will be blocked by the senators in blue states. And therefore, he doesn't care. He got his pound of flesh. He really doesn't care about Letitia James and James Comey. He already got he's got his pound of flesh because it was announced that there was a criminal investigation and then there was an indictment and then. And he's already moved on in his micro news cycle. But the strategy appears to be Department of Justice with a new prosecutor, new grand jury is going to try to indict both while the lawyers argue that it doesn't matter who's doing the indictment. It's all vindictive prosecution and try to get the indictments dismissed with prejudice forever. So we'll have to see what's going to happen next. And then in the next 25 days or so, they'll file a one-page notice of appeal to appeal what just happened to the Fourth Circuit Court of Appeals, which then goes up through, I think Judge Roberts takes care of the Fourth before it goes to the United States Supreme Court. This is all heading to the United States Supreme Court one way or the other. But that's the complicated developments. The last big development was that earlier today, Daniel Richman, a Columbia law professor who used to be a lawyer, or still is a lawyer for James Comey when he worked at the FBI and otherwise, who is the announced leaker. We all know he leaked on behalf of James Comey a series of memos to the New York Times when James Comey wrote CYA memos when Trump ordered him to stop the criminal investigation of Lieutenant General Michael Flynn, which he wouldn't do. He then leaked it to his buddy Richmond. Richmond leaked it to the New York Times. And the hope was, according to Comey, that a special counsel would be appointed. So that has always been the role of Richmond. Richmond had search warrants executed on him and had his email account at Columbia looked at, all of his electronic data looked at, and it was sitting in a giant box, including information that was attorney-client privilege for James Comey that he couldn't waive, information about other clients, and it was part of another investigation involving Hillary Clinton's emails. Fast forward 7 or 8 years, they turned that box that has all of the attorney-client privilege information and other private information in there, and they give it to a new FBI person to work with Lindsay Halligan in 2025. He runs roughshod over all of the documents, right? And violates the Fourth Amendment of against illegal searches and seizures of Professor Richmond and of Comey. Judge Fitzpatrick, the magistrate judge in the Comey case, said so on November the 17th in an order that he issued that they had violated the Fourth Amendment rights effectively of Richmond. Now, Richmond has filed a new motion to get back all of his material, which is all the evidence they have against Comey, apparently, and to have it not be used against James Comey because it would violate the Fourth Amendment privilege of Professor Richmond. That's now been assigned to a D.C. judge, Judge Kolar Catelli, who's a Clinton appointee, to make the final decision. So if the government loses on that motion and they can't use the Richmond materials, I don't know how they're going to ever bring an indictment unless it's about something completely different, which may be, and then of course we'll report on it here. And that's the link. Let me turn now to Alina Habba, right? Because that links to, we had Halligan thrown out by Judge Curry because that violated Section 546. She couldn't be the interim U.S. attorney because that position had already been filled by somebody prior to her. You only get one shot at that, and then the district judges pick after that. That's relatively simple. Alina Habba got her position a different way. She wasn't the interim U.S. attorney. She was the acting U.S. attorney. They went up a different statutory way. With her, that position can only be filled when there's a vacancy by the first deputy, the first assistant U.S. attorney for that office. There's a first assistant. It's the number 2 position in the office. Whoever is in that seat when a vacancy arises under the Vacancy Reform Act gets the job. Trump can fire that person, but then he's got to pick somebody else from within the office at the time of the vacancy who's got a year experience, or at least in that office, and 90 days of experience in the position that of first deputy. That's all he can do. So that's not what he did. He fired. There's a series of people, including a guy named John Giordano, who made it 3 weeks in New Jersey. Then they finally got around to appointing Alina Habba. They also nominated her. She got blocked by the New Jersey senators with blue slips. Donald Trump pissed off Donald Trump. So he had Pam Bondi also make her own first assistant and then try to elevate her as her own first assistant to the vacancy created by her being removed, and then also try to make her a special attorney without Senate confirmation to serve in the role of special attorney, U.S. attorney. Confused? The Third Circuit figured it out pretty quickly. 3-judge panel. We had a Bush, a Reagan, and a Biden appointee. And they were like, no, this is the simplest thing we're going to have to deal with. If you have a first assistant, you have to use the first assistant, and you can't be your own first assistant. So she's out. And then on the, can you a special attorney be created with all the powers of the U.S. attorney? They said, no, that violates the exclusivity provision of the Vacancy Reform Act, which says this is the exclusive way to fill the vacancy. Same problem that John Sarconi has up in Northern District of New York. He's the pit bull picked by Ed Martin and Pam Bondi to go after Letitia James in her official capacity as the New York Attorney General, claiming that she somehow violated the civil rights of Donald Trump because she brought a $400 million fraud case, which she won against Trump. There's still no one wants to talk about this. There's still a monitor, a court-ordered officer of the court over all of the Trump Organization business affairs. To this day, former federal judge Barbara Jones, because of the work of Letitia James. So she's now moved to quash his subpoenas, John Sarconi's subpoenas, Letitia James is arguing that Sarconi, like Habba, is illegally appointed under the Vacancy Reform Act for the exact same reasons that are in the Third Circuit Court of Appeals decision-making. Now, the Third Circuit Court of Appeal decision, while it's not necessarily binding on the judge that's handling the matter in Manhattan. See, they took it out of the Northern District of New York and put it in the Southern District of New York, because if Sarconi gets bounced, the judges of the Southern District of the Northern District have to pick his replacement. So they don't want to. They see an ethical conflict with the Northern District. They moved it down south to Manhattan. Okay, so we have that. So the judge there, if they determine that he was illegally appointed, what I was trying to say is on the Third Circuit, while it's not binding necessarily on the Southern District of New York judge, because her bosses are on the Second Circuit Court of Appeals that sits in New York up the street, not the Philadelphia-based Third Circuit, it is the only appellate ruling that's out there. So it does have a certain amount of binding precedent, a certain amount of persuasiveness that I think will be used by the judge. Welcome back. The Intersection, taken off like a rocket ship, all because of you. We're now in the top 30, our highest ranking ever, on Tuesday nights at 8 p.m. Eastern Time, exclusively on the Midas Touch Network. And then what we're trying to do is continue to build that audience. Come over to the audio version. The audio could use some help on the audio side, get that up and running. And then we could also use some help to make sure that we stay on the air with our mothership, Legal AF, the YouTube channel. Take a moment, become a free subscriber of Legal AF, the YouTube channel, and then also help us continue to grow our pro-democracy channel and the Intersection overall. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.